Welcome to the Litigating for Change Challenges, Opportunities, and Victories panel. Thank you so much for joining us. My name is Tony Ellis-Susan, and I am the Litigation Program Director at the Animal Legal Defense Fund. Now, I have the privilege to introduce our speakers, who are three all-stars of animal law litigation that I have the fortune of working with. Will Lowry is legal counsel for Animal Outlook and divides his time between undercover investigations and civil litigation. On behalf of Animal Outlook, Will is engaged in numerous lawsuits against government and industrial agriculture, including cases involving administrative challenges, false advertising, and animal cruelty. Will also supports Animal Outlook's investigations department in managing risk and seeking criminal prosecution for cruelty and neglect. Caitlin Hawks is Deputy General Counsel for Litigation at the PETA Foundation, where she oversees all offensive and defensive litigation. Most recently, her victories include partial summary judgment and a resulting permanent injunction under the Endangered Species Act, barring Wildlife in Need and Wildlife in Need, Inc. and its owners from declawing big cats, allowing big cat cubs to interact with the public, and separating mother cats and their infants. Her team also recently secured a victory at trial, resulting in a finding that Tri-State Zoological Park in Maryland violated the ESA by failing to provide protected animals with adequate veterinary care, sanitation, companionship, and environmental enrichment. Before joining the PETA Foundation, Caitlin practiced complex commercial and intellectual property litigation with Savat, Bruce, and Wiley LLP in Seattle and Milbank LLP in Los Angeles. She received her law degree from the UCLA School of Law. Christopher Berry is a managing attorney at the Animal Legal Defense Fund, where he leads key areas of its strategic litigation. Christopher works on a broad range of animal issues, including puppy mills, factory farms, and consumer rights. He helps formulate creative legal theories to help animals and challenge government agencies that are not following the law. Christopher also works to fight abuse on factory farms and protect consumers who want to make humane choices. Thank you all for joining us today. We will begin with a presentation from Will.
Hi, my name is Will Lowry. I'm legal counsel for Animal Outlook. I'm going to give a presentation today regarding litigation through the camera's lens. And what this presentation is about, it's about the value of undercover investigations, not just from a public exposure perspective, but also from a litigation perspective. I just first, before I begin, wanted to give thanks to ALDF and the Center for Animal Law Studies, as well as the moderator, Tony, and my co-panelists, Chris and Caitlin. I remember coming to this conference when I was in law school and just the value that I got from it, and I hope the folks watching today get the same value. I wanted to start off with a brief introduction to Animal Outlook, and I won't spend much time on this. We're a national nonprofit farmed animal organization founded in 1995. I'll let you read the mission there, but we have 4 key focus areas, and I'll be talking about 2 of those here today. Our first focus area is around exposing truth, and this relates to our undercover investigations. I'll spend a good bit of time today going through the value of those investigations, and then that will dovetail into the second point, delivering justice, which relates to what we do in the legal realm to use these investigations to try to bring justice for animals. We do have some other activities that the organization is engaged in, including revolutionizing food systems, as well as inspiring change. Our group does a lot of outreach to corporate entities, trying to change business practices, trying to reduce cruel behaviors. But what we're going to focus on today is our investigations and legal advocacy work. So I'm going to spend a few slides talking about the value of investigations. And we start with sort of the keystone point, which is animal welfare is important to consumers. I don't think this should be a shocking point. I think people in the grocery stores have seen the cartons and the labels depicting purported living conditions for animals. This is sort of borne out in studies, and you can see a couple of data points that I won't read through that talk about the extremely high percentage of consumers who value good living conditions. They want their animals to be well cared for. It is obviously very well known to the agriculture industry that consumers value animal welfare. And on the flip side of that, when consumers see bad treatment or poor treatment of animals, whether that's abuse or cruelty or neglect, consumers act differently. And I've included a data point here that shows that 63% of respondents said they would be less likely to buy meat if they knew that the animals were treated poorly. And so the agriculture industry, knowing this, these 2 points, one, that consumers value animal welfare, and two, that they would act differently or perhaps make different purchasing decisions if they knew the animals were being treated poorly, the agriculture industry tries to keep the public from seeing what happens behind the closed doors of slaughterhouses and industrial factory farms. This can take a number of forms. This can take the form of ag-gag laws, which I know that ALDF and others have fought long and hard against. This can take the form of security measures on farms, relationships with law enforcement, or even agriculture groups that are focused on activism that keep tabs on a group like ours and try to shed light on how are investigations happening, how can farms protect themselves. And so we start with sort of this keystone point that animal welfare is important to consumers. The industry knows that, and they try to keep it under wraps. Part of the strategy for the agriculture industry to do that is a term that's sort of coming in prevalence today. It's humane washing. You can see the labels here. I won't read through them, but there's a variety of different tactics and techniques that are intended to present an image to the consumer that's purchasing the product to show them that these are happy animals. They have some type of certification that alleges to provide great welfare. They live in pastures with trees or a red barn. There's no shortage of products. And I would encourage you, if you go to the grocery store, to spend a little bit of time looking at some labels and packaging and just sort of digesting the different designs and marketing images and pictures and certifications that are being used to try to depict to the consumer that animal welfare is at the forefront of the producer's mind, which in many cases it is not. Investigations are the counterpoint to that industry deception. And so now I'm going to shift into the value investigations and then really dive into the crux of the presentation today, which is how we use investigations in the legal world. And so investigations are generally the consumer's only view into this industry deception. If there were not investigations, people typically don't have the means to go visit a farm for themselves. And so they're left with these images on packaging. They're left with commercials and YouTube videos and social media. Investigations provide the counterpoint for the industry's deception. But above and beyond that counterpoint and sort of changing public perception, investigations serve another purpose, and they serve as the factual basis for litigation and prosecution. And that's what we'll talk about today. I know a lot of people think about investigations and they think about the video they saw and shared with their friend and how that may have influenced them to eat differently. But there's a power to investigations well beyond that, and that's what I wanted to shed some light on today. And so despite the agriculture industry's efforts, the public supports investigations. There's actually a lot of polls out there that show that the public endorses undercover investigations. They endorse efforts to get in and get footage and video of how animals are treated in factory farms and slaughterhouses. I won't read through all of these. You can see a variety of studies that show anywhere from 95% to 74% of people are supporting investigations. And so shifting now to some specific examples of investigation. So we've set the stage that animals, the treatment of animals is disguised by the agriculture industry. It's disguised on labeling. We've discussed investigations being important for changing public perception, but I wanted to highlight a few instances where Animal Outlook has engaged in cases related to litigation or prosecution and creatively made use of this investigation material. The first case that I'll highlight is our Superior Farms case, and this was a 2017 investigation into a lamb or a sheep slaughterhouse in California. We documented what we believe were violations of the Humane Methods of Slaughtering Act. We documented the facility changing Best Buy dates, failing to follow food safety procedures. And what came of this was a False Claims Act case. And so we don't have the time today to go into the False Claims Act, but rest it to say that it is a federal statute that lets individuals bring actions on behalf of the federal government when there is fraud being perpetrated against the government. And so in this case, Superior Farms was supposed to be abiding by the Humane Methods of Slaughter Act. They had contracts with the Department of Defense and the National School Lunch Program. And based on the actions that we captured on our video, it was our allegation that they were violating their contract with the government. So a False Claims Act case was born out of this. The Department of Justice intervened, which I believe was the first time the Department of Justice ever intervened in a case involving humane handling in the False Claims Act. And the case ultimately resulted in a consent decree. And I can't really go into the details, but there were a number of changes to handling practices at that facility. So this is a great example of investigation footage being put to work in sort of a novel idea related to a federal statute. And beyond, all the public exposure, there was litigation, and not only litigation, but successful litigation that came from this. Cook Aquaculture presents a bit of a different example. Cook Aquaculture is a salmon hatchery in Bingham, Maine that we investigated in 2019. We had an investigator there that documented a host of issues, and that investigator documented things like fish being thrown or stomped on, or fungal infections, fish with deformities. And that investigation ultimately led to a false advertising lawsuit in the District of Columbia. This lawsuit is still active. We actually just defeated 4 motions to dismiss by Cook Aquaculture, so we're in the pretrial stage, but we are challenging a number of claims made by Cook Aquaculture, and these are claims related to sustainability, to the natural characteristics of the product, as well as animal welfare claims. These are claims that Cook Aquaculture makes in their advertising and marketing, and that in part, because of our investigation footage, we identified that these are not the case. This is not a sustainable practice. There is not optimal animal welfare, and the products are far from natural. If we have tens and tens of thousands of fish living in concrete tanks, that is far from a natural process. So this case is ongoing, but again, a little bit of a different spin than the Superior case, in that was a federal statute related to government fraud. This is a false advertising case. So just another example of how these investigations can be used. And I should mention, if you look at the bottom of the slide, there is a bit of a disclaimer. There are some images in this presentation that some might consider disturbing, so feel free to look at the bottom of the slide for the asterisk to see if there's one coming up. The next one that I'll talk about is Quality Pork Processors. This is a 2015 investigation at a Minnesota pig slaughterhouse. This has actually been a very important case for us, and it's being used in a number of different litigation activities. We had an individual that was at the slaughterhouse, and at the time, this was one of 5 slaughterhouses that were operating at high line speeds, meaning that the plant could slaughter pigs as fast as they wanted with no limit on that. And so these videos that captured all sorts of abuse, you can see some of it there to the bottom right. We saw a lot of abuse to downer pigs, so pigs that could not walk were being electrically prodded, kicked, beaten. We saw food safety issues. We saw, carcasses with pus and different substances that might cause food safety concerns. We saw a supervisor sleeping on the job. We saw a number of activities and have used this for 2 different litigation opportunities. The first litigation opportunity is a lawsuit in which Animal Outlook is a plaintiff, along with a number of other different coalition groups. And so we are a plaintiff in this case against the United States Department of Agriculture. In this case, is challenging federal rules that allow reduced inspectors at the slaughterhouse, as well as allowing increased line speeds. This material is provided extremely valuable content for our lawsuit. It has provided information to counter some of the USDA's claims that fast line speeds do not result in inhumane handling. It has provided content to help Animal Outlook with our argument that we are an appropriate plaintiff for the case. And so that is being used in a case against the USDA for line speeds. It is also being used in a separate case against the USDA for the treatment of downed pigs. And again, a lot of what we captured relates to downed pigs and their treatment. And so you can see here 2 separate lawsuits, both against the USDA, 2 separate challenges being raised to help animals, to help pigs specifically at slaughter. And we are making valuable use of this investigations material, in addition to all the public exposure it has garnered and hopefully the behavioral changes it has driven. The quick update on that case is that there was a motion to dismiss that was recently defeated, and thanks to our coalition partners, as well as Lewis and Clark and Green Fire Law, who are leading the charge on that case. The next case is Amick Farms, and again, I think this is a great example of yet another way to use investigations material. So if I recap, we've looked at a federal statute related to fraud against the government, we've looked at false advertising, we've looked at administrative challenges to the USDA. Our Amick Farms case provides yet another example of ways to use creative litigation and make use of investigations material. So Amick Farms is a chicken slaughterhouse in Hurlock, Maryland. Amick Farms is operating also under a USDA program that allows faster line speeds, this one for chickens versus the pigs that I just talked about. We documented, as you can see here on the slide, a number of different incidents. We documented workers throwing chickens into shackles, lines breaking down, and chickens being submerged in stun baths until they drown, food safety issues with green pus or tar-like substances on the carcasses of chickens. A host of activities that we documented here have now informed a couple of different lawsuits. The first one is similar to the last slide I mentioned. This is an administrative lawsuit challenging the USDA's decision to allow Amick Farms and others to operate at high line speeds and with reduced inspectors. Again, that's part of a coalition effort with a number of wonderful animal protection organizations. But what's new and different here is that we have recently brought a second case based on our Amick Farms investigation. And this is a public nuisance case. And this is a case brought specifically against Amick Farms, alleging that their mistreatment of chickens, that their violations of food safety protocols constitute a public nuisance. I'd be remiss not to give credit where credit is due. This is a theory that ALDF and others like PETA have worked on for a long time. And so we have now applied that theory against Amick Farms in Maryland. And that case is now in a state court. But yet another example of a different type of litigation activity that can be brought based on investigations material. A couple more examples here. This is Martin Farms, and we're going to take a shift now from civil litigation into criminal law. So Martin Farms is an industrial dairy farm in south central Pennsylvania. We had an investigator employed at Martin Farms in 2018 for several months. That investigator, just like every other investigation that we've done, documented abuse and what we believe was cruelty and neglect to the animals there. I know, as a side note, a lot of people think that, you've done an investigation, you found cruelty, but that's a one-off or that's an anomaly. Animal Outlook has done 35 investigations since our inception, and there has not been one where we did not see issues. It is just the nature of the beast as it comes to industrial factory farming. And Martin Farms, just like every other facility, there was abuse, there was neglect, and there was cruelty. And so in this case, we documented incidents like improper euthanasia, veterinary procedures that were completely botched and not performed by a trained veterinarian. We documented cows being pushed and prodded with tractors or lifted high in the air with metal hip clamps. And so we documented all that information, and as we almost always do, we pursued prosecution against Martin Farms, the corporate entity, as well as individuals for violation of Pennsylvania's animal cruelty and neglect laws. That has been a long and arduous road, and it took the Pennsylvania State Police over a year to finally come back and declare that they were not pressing criminal charges. The thing about Pennsylvania is there is a very unique procedural avenue where a private citizen can file a private criminal complaint. We pursued that. The prosecutor, as expected, denied it. We appealed that to the local felony level court, who denied it as well. And so now this case is on appeal to the appellate court of Pennsylvania. We're currently awaiting oral argument. The key thing about this case is that now that we are at the appellate level, we have the opportunity to make some solid case law if we are able to be successful here. We are challenging not just specific incidents that happen, but essentially the state of Pennsylvania's interpretation of the common practices exemption that allows in many states cruelty to farmed animals. And so our hope is that this leads to a favorable decision and that we can sort of narrow the bounds of that common practices exemption such that more and more practices that we believe are cruel are now considered cruelty under Pennsylvania law. So again, another example of a way to use investigations material, this one in the criminal justice realm versus civil. And then the very last example that I'll give you is more recent, and there's a lot to this, so bear with me. This is related to Bravo Packing. Bravo Packing is a slaughterhouse in South New Jersey that slaughters cows for dog food, as well as horses for exotic animal food. We have been working on Bravo Packing for quite a while, even outside of our investigations, and have had some success through the FDA getting products recalled. We did an investigation at Bravo Packing earlier this year and documented a downed cow being dragged off a trailer by a chain, improperly stunned 4 times over the course of about 10 minutes, and then ultimately hoisted up and slaughtered. This presents a number of issues, and we've written complaints to a number of government entities, but they can really be categorized into 2 buckets. The first is animal cruelty issues. And so we allege that the actions in dragging the cow, improperly stunning the cow, violated a number of laws, including the Humane Methods of Slaughter Act, New Jersey's Humane Treatment of Domestic Livestock Act, as well as New Jersey's state-level animal cruelty law. And we also allege that there were food safety violations, both at the FDA federal level as well as the New Jersey Department of Health level. We have complaints in with all of those entities making arguments related to those laws based on our investigation's footage, and we are currently awaiting the outcome. So that's the last example, but I think what I'd like to do is just put a ribbon around that before I move to the final slide. Investigations, as you hopefully are well aware, are incredibly important for 2 reasons, not just for public exposure or public perception, changing behavior, causing consumers to make dietary or food purchasing decisions, but they serve a purpose that many people don't know about, and that is to feed litigation and prosecution. And so you can see from the variety of cases that I've given today that this material is incredibly valuable. It can be used not only in administrative cases, it can be used in false advertising cases, torts cases like our nuisance case, criminal prosecutions, food safety cases. And it's for these reasons, both the public exposure as well as the utility of this material, that we value investigations, and hopefully the rest of the animal rights movement values it. And that's why we and others fight tooth and nail to keep the ability to conduct these investigations, both for the public exposure as well as the utility through the courtroom. And then the last thing I'll leave you with is just a quick update or highlights on challenges related to investigations. I won't go into a lot of these in detail just because some, as you might expect, are sensitive and confidential, but I can highlight a few. If you're not familiar with ag-gag laws, I would encourage you to spend some time on that, but a number of states have passed these laws, and as I mentioned earlier, groups like ALDF and others have been fighting and successfully in many cases challenging these. These are laws that attempt to prevent recording in facilities or attempt to prevent people from gaining employment in facilities under the guise of being employed there and then recording footage. Some of these laws require rapid reporting requirements to try to ferret out any investigator sooner rather than later. So these laws are obviously a challenge for investigations. The industry spends millions and millions of dollars proposing, lobbying for, and championing these laws. The second item here should be obvious. It's just the physical and mental toll on investigators. I will be sort of the loudest champion for our investigators. These are some of, if not the most special people that I've ever worked with or encountered in my life, but they take a toll for this work. As you can imagine, it's not easy to be in a slaughterhouse or to watch cows being hit with a metal pipe or chickens thrown into shackles. And they do this work and they take that toll for the benefit of the greater good. And so that's obviously an implication or a risk to be dealt with as well. One of the other issues that we encounter very regularly is prosecutor disinterest. And so if we go to an entity and request criminal charges against a corporation, more often than not, the prosecutor has no interest. They don't want to cause concerns in their local community. They are not familiar with the law. They don't think the law applies. They don't have the bandwidth. I've heard all of the excuses from prosecutors, and so that's continually a challenge, is to make use of these investigations materials in the criminal justice system. And a lot of that difficulty is why some of these cases we shift to the civil justice system or to the civil system and look for things like tort suits or administrative suits. And then there are other risks that I won't go into for confidentiality reasons, but I think what I'll leave you with is just a closing remark and repeat what I said earlier, which is that investigations are incredibly important. Whatever people can do to support them, champion them, fight for them, keep the right for individuals and groups like Animal Outlook to see into the confines of a factory farm or a slaughterhouse, it is incredibly valuable, not just to change public perception and to keep the industry from fully pulling the veil over people's eyes, but it is also valuable for bringing about meaningful change through the court of law. And so that's all I have. Again, thanks to ALDF and the Center for Animal Law Studies, and look forward to questions.
So my presentation today, which is called Spoliating Tigers, has to do with evidence preservation issues in Captive Animal Endangered Species Act lawsuits. And specifically, it has to do with the preservation of the animals themselves as evidence. I'm going to discuss these issues through the lens of 3 different cases that PETA has brought over the last several years. All of them have to do with captive big cats, so either tigers or lions or both, who are protected under the Endangered Species Act. The first one is PETA Inc. versus Dade City's Wild Things, which was a case we brought in the Middle District of Florida. The second is PETA versus Wildlife in Need and Tim Stark, which was a Southern District of Indiana case. And then the third, which is really in its infancy, and that actually has not technically been filed yet, and I'll get into that in a little bit, is PETA versus Jeff Lowe, which we are hoping will ultimately be pending in the Eastern District of Oklahoma. So I'm going to talk about evidence preservation tools that fall into sort of 3 categories. One is pre-filing. So under the Endangered Species Act, there's this sort of complicated situation that arises as a result of the fact that the ESA requires that you provide defendants with 60 days of notice before you can actually file suit against them. What that means is you draft a notice letter laying out what your claims are and what they would have to remedy in order to avoid lawsuit, and then you send this both to the United States government because they can take action on your claims, and then also to the defendants to provide them with notice. During this notice period, evidence preservation issues often arise because the defendants now know they're about to be sued, but you're not yet before a court, so you're sort of limited in the options you can pursue in order to make sure that they're not, for example, transferring animals out of the facility or otherwise hiding them. So in that context, we're going to talk about preservation tools in the form of just kind of calling out the defendant's common law obligations in a document preservation letter or as part of your notice of intent to sue. And then also a preservation order under Federal Rule of Civil Procedure 27. Which is an atypical use of that rule, but something that we have had a fair amount of success with just recently. Once you file your Endangered Species Act suit, so after the 60-day notice period has run, you then get into some broader options that are available to you in order to ensure that the animals at issue in your case are preserved and you can actually gather evidence about them and the conditions in which they are living. You can seek a preservation order from the judge who now has jurisdiction over the case that's been filed before him or her. And then sometimes preliminary injunctive relief will help you. That's not specifically something that pertains to evidence preservation alone, but it can certainly have an impact on evidence preservation for other reasons. And then finally, once your defendant engages in misconduct, which you would hope to prevent, but oftentimes we're not able to do so, you have a number of other options available to you for addressing that misconduct. These include moving for spoliation sanctions, moving for sanctions under Rule 37, moving for some sort of relief under the court's inherent authority, and if you've been lucky enough to get orders in place that protect the evidence and your ability to access it, you can move for contempt of those orders. So Dade City's Wild Things was a case that PETA filed in Florida, as I mentioned, against this facility that bred endangered big cats for use in public encounters like the one depicted here. We filed suit to challenge these activities, and early on in the case, one of the things that we did in discovery was seek a site inspection of the facility. This is something that we routinely do in all of our Endangered Species Act cases. Federal Rule of Civil Procedure 34 is the rule that typically governs production of documents, but also has a provision for an entry upon land and inspection of the premises to the extent that the premises are relevant to the case that you've brought. And here, the premises include, the conditions in which our ESA protected animals are housed and maintained. And so we always move for site inspections in these cases. the defendants always put up a big fight about that as well. So we had to move to compel the site inspection against Dade City's Wild Things here. And we won on that motion to compel. So we were preparing to go in and do our site inspection and document these tigers who we were suing over. But 2 days after the court entered its order granting our site inspection request, we heard through the grapevine that the defendants were actually working to move the cats off site so that we were not actually able to see them. So we went back to the court and we sought an emergency preservation order asking that the tigers be preserved in place so that we could actually go in and document the conditions. The court likewise granted that motion. Despite that, though, the defendants still began moving the animals that same day. They moved them to a facility out in Oklahoma called the Greater Wynnewood Exotic Animal Park, which was owned by Jeff Lowe and operated by Joe Maldonado Passage, also known as Joe Exotic. Both of those guys you may be familiar with if you've seen the documentary Tiger King. During the course of that transfer from Florida to Oklahoma, one of the tigers who was on the transport truck gave birth. It was the heat of summer. There was no climate control, and all 3 of her cubs actually died. So this conduct was egregious for a couple of different reasons. And so when we showed up ultimately then to conduct our site inspection pursuant to the court order, not only were there no tigers there for us to see, but the defendants wouldn't even allow us access to the facility. So we filed a motion for sanctions and for contempt of the court's prior 2 orders. Our motion for sanctions was based upon 2 separate grounds. The first of those grounds was Federal Rule 37. This is a rule that specifically allows for discovery sanctions, and it specifically contemplates that in the case of particularly egregious misconduct, which is what we were dealing with here, you can get a default judgment, and then likewise you can get contempt of court to the extent that the defendants have disobeyed a specific court order, or as in this case, court orders, plural. So we moved under the provision that's listed here, 37B2A 6 and 7. We also, as an alternative basis for the sanctions we sought, moved under the common law governing spoliation sanctions. Essentially, Rule 37 codifies this law, so much of the relief you can get under the law of spoliation sanctions is kind of similar. We sought, again, a default judgment on this basis as well. Typically, when you seek a default judgment pursuant to the law of spoliation sanctions, you have to show that the defendant engaged in bad faith, and likewise that lesser sanctions that are available for spoliation will not suffice. So here those lesser sanctions would have been like an adverse inference or rebuttable presumption instruction to the jury. In most of our ESA cases, and certainly in this one, there actually is not a jury. We typically try these matters to a judge because we are only seeking injunctive relief, so a remedy in equity as opposed to at law, and there is not generally entitlement to a jury trial in those circumstances. So there was no jury to whom an adverse instruction could be given. And likewise, the conduct was so egregious that striking the pleadings or simply awarding fees and costs really wouldn't have been sufficient to address it. So we made these requests of the court. The court, in that case, we sort of tried this to a magistrate. The hearing on the contempt motion and the sanctions motion ended up being kind of a mini trial type thing. And the magistrate issued a report and recommendation that our request for default judgment be granted, and then the district court affirmed that. It's also worth noting, and it didn't come up in this case because we were in the Middle District of Florida, but in many cases that have to do with spoliation, you have to meet these specifically articulated elements in order to prove that spoliation has occurred. So they're listed here in this Zubilate case, which is sort of a seminal case on electronic discovery, but also has bearing on any other sort of spoliation that might occur. So first you have to prove that the party you're challenging had control over the evidence and an obligation to preserve it. Second, you have to prove that the records were destroyed with a culpable state of mind. And then finally, that the records were actually relevant to the party's claims or defenses. And that's something that would very likely come up in many jurisdictions around the country. So this is sort of the happy after picture. So as I said, we won default judgment in the case. The result of that is that we were able to place all of the animals who had been relocated from that facility to reputable sanctuaries. This particular tiger is named Remington. He's now living out a happy life at Turpentine Creek Sanctuary in Arkansas. So now, after Dade City's Wild Things had kind of taught us a lesson about what type of misconduct we should anticipate, we started seeing defendants kind of engage in similar patterns in other cases. Actually, shortly after Dade City's Wild Things, we sent notices of intent to sue in a couple of other cases, and as soon as they got them, the defendants transferred their animals off-site. So we started thinking through how we could get creative about preventing those types of things from occurring whenever we sent out our notices of intent to sue. The next suit that we pursued wherein this became a real issue and we kind of started pursuing some of these more creative remedies is the one referenced here, PETA versus Wildlife in Need and Wildlife Indeed, and Tim Stark, who is the facility's owner. He was also in Tiger King. In that case, we had a reasonable basis to believe that Mr. Stark would try to transfer animals off-site in order to hide them from us. Mr. Stark habitually kind of traded in tiger cubs, moved them back and forth around the country, and so we knew that he had the ability to transfer the animals away. So we therefore filed a motion under Federal Rule 27. Typically, this is a rule that is used in order to preserve deposition testimony if, for whatever reason, you can't file suit yet, and you think that somebody who might have key evidence about whatever it is your lawsuit is might die before they are able to testify before the court or leave the jurisdiction. The rule, though, also mentions specifically that the court may issue orders like those under Rules 34 and 35 as well before you actually file suit. So Rule 34 is the rule under which we seek site inspections. So during the 60-day notice period, we filed a miscellaneous action. So it's not like the main action in which you actually file your ESA complaint, but just this narrowly focused action setting forth this Rule 27 motion, where we asked to go in and inventory the animals at Stark's facility so we would know down the line if he illegally moved animals out of there. So under the rule, we asked both to depose Mr. Stark to create this inventory that we wanted, and then also to go into the facility to inspect and verify that it was accurate. The court in this case, unfortunately, indicated it was not likely to rule in our favor at the hearing. The judge did, though, acknowledge explicitly that the defendants still had a common law obligation to preserve their evidence. So any time that you anticipate suing or being sued, you have an obligation that attaches at that point to preserve any evidence that could be relevant to the case. And certainly Mr. Stark had that obligation here. And so because the court kind of said this on the record, the parties actually entered into a stipulated preservation order obligating Mr. Stark to preserve the evidence in his possession, including the lions, tigers, and hybrids at issue in our lawsuit. This wound up being very useful because almost as soon as the lawsuit was filed, he started trying to transfer those animals. We also, as soon as we filed the case, we also moved for preliminary injunction to enjoin some of the most egregious conduct that we were challenging in the lawsuit. That included declawing of big cats and also separating them from their mothers prematurely so that they could be used in public encounters. We won the preliminary injunction, and the impact of this was that we also then, in addition to the preservation order, had another mechanism to prevent Mr. Stark from transferring cubs because he was now not allowed to separate them from their mothers in order to send them to third parties. So as the lawsuit proceeded, both of these orders wound up coming in very handy for us. So Mr. Stark, at some point early on in the litigation, separated 3 big cat cubs from their mothers and transferred the animals out of the facility. This violated both the preservation order and the preliminary injunction. Shortly thereafter, or some period of months thereafter, he also entered into a partnership with Jeff Lowe, who we were familiar with from the Dade Cities case that we just discussed. And he transferred title to all of his big cats to Mr. Lowe. At that point, when we found out about that, we sought to clarify the existing preservation order to make clear that Mr. Lowe was not allowed to move the cats off of the property to his own facility because that would violate the order that Mr. Stark had previously agreed to. The court granted that motion and made clear that the preservation order likewise barred Mr. Lowe from taking the cats off the premises. Despite that, though, Mr. Lowe actually did take 4 cats from Wildlife in Need to his facility in Oklahoma. And so the fact that these orders were in place meant that we were able to move for contempt of them in order to remedy this misconduct. The cats who were remaining at Mr. Stark's facility, though, also continued to suffer. So during the course of the litigation, evidence preservation issues also arose with respect to those animals, the ones who hadn't physically been transferred to Mr. Lowe. It became apparent during the course of the litigation that things were getting really dicey at Wildlife in Need. There were multiple animals who died. There was no attending vet associated with the facility. And volunteers were providing incorrect dosages of medication to the animals. So in order to address these urgent concerns, we used yet another tool in our arsenal and filed a motion under the court's inherent authority to try to get the animals moved to an appropriate sanctuary on an interim basis. So the authority that the court has as part of its inherent authority is arguably a bit broader than the relief that you can seek under Rules 27 and 37. Typically, the latter preserves the status quo, whereas here we had a little bit more latitude to ask that the animals be, in fact, transferred off-site so that they didn't die during the course of our litigation or otherwise suffer during the course of our actual litigation. As with our contempt motion, though, this motion appealing to the court's inherent authority was never actually ruled upon by the court. Rather, we ended up moving for summary judgment, and the court entered a ruling granting summary judgment to us. I really think, though, that even though we didn't get a ruling on the contempt motion and this inherent authority motion, that the sort of crisis atmosphere that was created as a result of these various motions made the judge a bit more willing to grant the full relief that we sought. Also under the court's inherent authority, or relevant to that, it's significant to note that the Indiana Attorney General filed suit while our lawsuit was pending against Mr. Stark relating to his failure to operate his zoo in line with its purported charitable mission. And in that case, the Indiana Attorney General was actually able to get the animals transferred to sanctuaries on an interim basis. So there is reason to expect that in a situation like this in the future, this might be a useful tool for private groups as well. This is the happy after photo of Tim Stark's animals. These are some of the rescued cats playing at the Wild Animal Sanctuary in Colorado. And then the final case I want to cover is kind of in its infancy, but as you've already gotten a good sense for at this point, Jeff Lowe has a long history of mistreating animals. He's inserted himself into 2 of our lawsuits alone, but likewise on his own has operated a number of facilities where animals have suffered immensely. So in late 2020, PETA sent Mr. Lowe a notice of intent to file suit under the Endangered Species Act. For obvious reasons, we had serious concerns about Mr. Lowe trying to hide evidence during the pendency of that suit. So we yet again used Rule 27 in order to seek to depose Mr. Lowe and his wife and a business associate of his, and to conduct a site inspection of his facilities of his facilities so that we could create an accurate inventory of the animals there, and we'd know down the line if they were transferred off-site. In this case, the motion actually was granted, so we were able to conduct these depositions and to go in and lay eyes on the animals. This ended up being very useful because 59 days after we sent our notice of intent to sue, the United States government actually filed a civil lawsuit against Mr. Lowe. And in its civil lawsuit, it actually cited, as part of a warrant request, some of the deposition testimony that we were able to obtain as part of our Rule 27 order. And it actually ended up that one of those depositions sort of served a traditional Rule 27 function, in that one of the deponents, a guy named Eric Cowie, just passed away like a week or two ago. And so now, thankfully, we have his testimony preserved going forward. So this slide that I'm showing you here now is actually an excerpt of the warrant request that the Department of Justice served, and the highlighted portions are just a few of the excerpts from our depositions that it relied upon in securing this warrant. So where the case stands now, from PETA's standpoint at least, is we have moved to intervene as a co-party in the government's lawsuit against Mr. Lowe. So our motion to intervene is currently pending before the Eastern District of Oklahoma, and we hope to have a decision on it imminently. So that's kind of the overview of the tools that we have used in order to preserve animal evidence in our Endangered Species Act cases. And that is all I have for today.
Well, thanks, Will and Caitlin, for your excellent presentations. My name's Christopher Berry. I'm a managing attorney at the Animal Legal Defense Fund, and I'll be talking about animals as named plaintiffs and clients, which presents some really interesting and important legal issues as well as practical issues. And I'll be talking about this primarily within the context of my own experience representing Justice the Horse in the Animal Legal Defense Fund's case, Justice v. Vircher, which I'll get into in just a minute here. But before I launch into that, the lived experience and legal issues related to that case, I want to step back a bit and just talk about the context in which this discussion is occurring. That the American legal system is an anthropocentric one. So that means it's centered on humans. And humans are the attorneys, humans are the judges, and humans are usually the people that being represented in courts, the plaintiffs and defendants. And when they're not, it'll typically be a corporation who is acting through humans. And so, as a result of that, just take like a medical malpractice case, for example. You're going to have perhaps like an adult human who's been injured, and they're going to engage with a lawyer, going to go to court, sue a hospital, and drag the doctor into that lawsuit and everything. That system of attorney-client ethics and how decisions are made and who sues works well when we're dealing with human interests. But the law doesn't only exclusively recognize and protect human interests. The law also protects animal interests. And there is, in fact, a large disconnect between the law recognizing animal interests not to be, cruelly abused or inhumanely slaughtered, for example, and the right of the animals to have those interests vindicated in court by litigators like everybody presenting in this panel today. Some of the barriers and the ways in which representing animals is challenging. First and foremost, animals generally aren't recognized as having standing. So in order to to go to court to have a legal right vindicated, to be a named plaintiff in the first place in a lawsuit, you have to have standing under federal law. And the vast majority of states have a statutory or constitutional requirement for standing as well, with some exceptions, but really the general rule is that you need to have standing. So you need to be a person who's been injured in order to go to court and have a legal right redressed. In addition, the way that some things are set up with regards to attorney-client relations and how those decisions are made, typically assume a competent adult is making the decisions. There can be challenges about strategy and settlement and professional ethics where you're dealing with someone who doesn't have capacity, not only an animal, but potentially a child, for example, or a comatose adult. And so, there's solutions to that, but really that can be a challenging background in which to think about and consider all of this. In addition to being logistically problematic in terms of who is standing and who's the client and who makes decisions and those types of questions when you're dealing with animals, there can be a lot of injustice and inequity resulting from this kind of a system. I've seen plenty of meritorious lawsuits alleging real legal problems, animal cruelty, animal welfare violations, inhumane slaughter, and things of that nature, where there's a legal problem, and animals being terribly mistreated, and then the case gets thrown out for lack of standing because our system hasn't yet recognized that animals have the ability to go to court. And sometimes there's not always a human or a corporation who can go to court on their behalf. And that really is the workaround in this sort of a situation, is to find a human or a corporation that themselves coincidentally have standing and can act sort of like a surrogate for the animal themselves. But when you can't find that person, or when the court says that human doesn't have standing, then you see inequitable and unjust results. So with that backdrop in mind, I want to pivot a bit and talk about our lawsuits, Justice v. Vircher, which is a case that the Animal Legal Defense Fund developed and brought, and that I've had the privilege of working on. Justice is a horse in Oregon, and the background of his situation is that he was alone. He was cold, he had frostbite, lice, brain rot, he was severely underweight, and a neighbor called to complain about his condition. Ultimately, his now former owner, decided to surrender him. She was charged with animal abuse because of the neglect that he had been enduring, and so she signed away her rights to justice and agreed to pay criminal restitution for his cost of care up to the date that she made this plea agreement. However, Justice's his damages, the injuries that he suffered, behavioral support, and other additional costs of care that he would need relating to his neglect, they outlived that criminal plea deal. So there are still additional damages that he has suffered, additional needs that he has that weren't compensated by that criminal restitution agreement. And when we learned about this, we filed a lawsuit on Justice's behalf, where Justice is the named plaintiff, and he alleged negligence per se, which essentially is that it's a negligence lawsuit where the standard of care, the question of whether there was a breach of a duty is answered by looking at the law, whether there was a statutory violation. And in this case, the statutory violation was an animal cruelty violation. So there was a duty by his former owner to take care of him. And that duty was breached by violating the animal cruelty law and causing him injuries. And those harms are ongoing and still haven't been compensated. So we filed this negligence per se lawsuit on his behalf. And it was, after a few months, dismissed by the trial court. And the trial court said that essentially that Justice didn't have standing. This was about a one and a half page letter decision by the court. Simply reiterating that no one had recognized animals as being persons with standing in the past, and this court wasn't going to take that leap. So we appealed that decision about 2 years ago, and it's in fact pending on appeal. So there hasn't been a resolution to it. But the main issue on appeal is whether the trial court erred when it dismissed the lawsuit based on lack of standing for Justice the Horse. That's sort of the background for the case. I'm going to talk about a few of the legal issues related to representing justice and some of the related practical aspects of that as well. One of the issues that was raised in the appeal briefs in the lower court, but wasn't addressed by the trial court judge, and so I don't think it's properly a part of the appeal, is a question of guardianship. So the other side had made a point that the person who is Justice's guardian didn't have the authority to act as his guardian. And not only is that not a proper issue on appeal, but in fact, Oregon law does recognize that an incapacitated person may appear automatically through their guardian. And the horse sanctuary, Sound Equine Options, that has custody of Justice, the director of that organization has physical custody. It does take care of him, is in fact his guardian. And so we argued that because she is the guardian, that the guardianship question is resolved in our favor. In the alternative, the statute in Oregon, which is largely mirrored in other states and federally as well, you could also have a procedure to appoint a guardian as well. And so, of course, we offered to do that if the court wanted us to. And I'll just make a last point, too, with regards to guardianship, right, which is sort of like a bigger question of when you have an animal who's incapacitated, who actually gets to represent that animal's interest? Like what human can actually speak for the animal? At the very least, courts do have inherent authority to craft procedures in order to ensure that justice is done, so to speak. And so even in a situation where there wasn't a statute that automatically provided for guardians to represent an incapacitated person under their care, courts, I think, as a general rule, would be able to use their inherent power to recognize a guardianship. There's a practical aspect to that as well, which is the fact that we had to even have an engagement letter, which I think is a sort of an interesting aspect of representing animals, that attorney-client ethics and professional obligations apply to the animal and not to a human or corporate client that might be sort of acting like a surrogate for the animal's interest, but is really owed to the animal themselves. So we do have a formal engagement with Justice that was signed by his legal guardian, Kim from Sound Equine Options, and sort of another related issue with engagement is this question about payment, right? A lot of typically lawyers will ask to be paid in their engagements, but animals don't typically have money. Maybe a handful of them do have a trust or something like that, which can be created under law, but for the most part, they don't have money. They won't be able to pay their lawyers. And so an attorney-client relationship between a lawyer and an animal is almost definitely going to be a pro bono relationship, which is an important practical thing to consider, and also really undercuts the argument that we've heard from the other side, which is that that the floodgates are going to burst open if animals are able to have standing. The reason I don't think they're going to burst open is because someone's going to have to pay for the attorney time, including the attorney themselves if they're doing it pro bono and not getting compensated at all. And so as a practical matter, only meritorious cases, I think, would ever be brought, even if animals, do have the right to go to court and have standing, as we're arguing in this case. Moving on then to another legal issue in the Justice case, which is really the key issue on appeal, as I said earlier, is this question of standing. Who is a legal person? What is the definition of a legal person who has standing to bring a lawsuit? In order to have standing, you have to be a legal person. And the word person, I think, trips people up quite a bit. It's a loaded term that has a lot of different meanings in different contexts. One context is just the sort of cultural and linguistic definition of person. And oftentimes it's used synonymously with human being. And so when you say that an animal or even a corporation is a person, that can be jarring for some people who are used to using the word as a synonym for being a human being. If a legal person could be more than a human being, then like what is the definition of a legal person? In the justice case, we're arguing that a legal person is anyone who has legal rights under the law. So if there's a law that provides rights, then whoever receives those rights is a legal person, at least with respect to those rights. It doesn't necessarily mean that you're a legal person in the exact same way that every other legal person is. It just means in the context of an animal, for example, that if you have the right not to be cruelly abused or neglected, that makes you a legal person with respect to the animal cruelty law. It doesn't necessarily make you a legal person with results to constitutional rights, citizen rights, or any other rights for that matter. It's just that where a legislature has specifically said that animals have the right not to be cruelly abused, that they are in fact a legal person with respect to that law. And that is going to be really the main, I think that will be the main issue that the Oregon Court of Appeal will be addressing, which is this sort of idea of kind of a limited personhood or legal personhood that's limited to these particular rights, and whether the animal cruelty law is a law that provides those rights, as some previous Oregon courts have said. There is then a related issue to standing, which is real party and interest, which doesn't get talked a whole lot in the animal conversation, but is actually a really interesting issue. I think it actually compels justice to be the named plaintiff in this lawsuit, rather than somebody else like Sound Equine Options, the rescue group that has been taking care of him. And what the real party and interest is the real party and interest is a person who has a right at issue and sustains the direct injury, right? And so this could be a little confusing because it sounds so much like standing, but there are some situations where someone might have standing, sort of in a general sense, but not necessarily for like any particular damages in a case. So I think a good example to illustrate that would be a hiker who likes to go through a forest, would have a aesthetic standing or aesthetic injury to stop illegal cutting of a forest that they like to go through. But they wouldn't have standing, or they wouldn't be a real party in interest with regards to the loss of property value for a neighboring house. That lawsuit for the damages for the loss of property value for illegal forest clearing would be something that only the homeowner would be able to bring. And so the way that would apply here is that justice is the one who has suffered and who will continue to suffer and need additional costs of care. And it should be him who receives money to compensate him for, veterinary care, behavioral training, extra sheltering costs, and so forth going up through his life. In fact, if it was anyone else who could recover those damages, then the original abuser actually might be subject to an indefinite series of lawsuits from, first from a person who provides immediate care for an abused animal, then a sanctuary who has them for a while, somebody who adopts the animal from the sanctuary might spend money on veterinary care. That person, something might happen to that person, or custody changes again, and none of this would be going in his name, and the person who is the defendant might be defending themselves against multiple lawsuits. And so the real party in interest, which is related to standing, I think really sort of dictates that justice be the plaintiff in this case. And then lastly, another legal and practical issue as well that I want to touch on is the question of remedy, who receives the damages. And if you just give a pile of money to an animal, they wouldn't know what to do with it. And so in Justice's case, we've already created a trust, and we just ask that the damages be deposited into the trust. and a trustee will be responsible for using the money in justice's interest. So that's justice's case and some of the legal and practical issues relating to that. The outcome, as I said earlier, is still to be determined. And, in the coming weeks or months, I expect a decision from the Oregon Court of Appeal, and then from there it could go to the Oregon Supreme Court. So I'm going to spend my last couple of minutes here talking about a couple of other cases where animals were named plaintiffs, just to provide some context for this and to demonstrate that this is an area that has been receiving some more attention in recent years to address those inequities that I was talking about earlier. The first case is Naruto v. Slater, which was a 2018 decision by the Ninth Circuit Court of Appeal. And that is the famous monkey selfie case. So PETA alleged that Naruto had the copyright to the selfie that Naruto took, and that the proceeds from that selfie should go to Naruto rather than to the photographer who lent Naruto the camera. The Ninth Circuit said mainly that the Copyright Act doesn't give standing to animals, but it also had an interesting discussion about next friend status. And next friend is it's kind of related to guardianship, which I was talking about earlier, and this question of who has a right to act in the legal interest of an animal or an incapacitated person. Under federal law, next friend essentially has two elements that have to be satisfied. One is that there is inaccessibility or mental incompetence or some reason why the person needs a next friend in the first place. And for an animal, that I think certainly that incapacity or incompetence would be the rationale for that. And then the second element for next friend standing is that the person who's acting as a next friend must be truly dedicated to the best interest of the person on whose behalf they seek to litigate. And usually this is interpreted as requiring some kind of special relationship. So the Ninth Circuit said that because PETA didn't have a special relationship to Naruto, that they didn't qualify as the next friend. I'm very critical of that decision because there are situations perhaps where animals or even other humans don't have that kind of a special relationship with anybody who's willing to bring a lawsuit, or maybe anybody at all who's a capacitated human. And it's grossly inequitable to say that in those situations you need to have a special relationship. Then the question really is just, do they have the best interest of that person in mind? And I think certainly for an animal protection group would have the best interest of an animal at heart, except maybe under some extraordinary circumstances. And then the last case that I want to talk about, in addition to the Naruto one, is a non-human rights project, XREL Happy v. Breheny. And that is a case that is currently being considered by the New York Court of Appeals, which is the highest court in New York, on behalf of Happy the elephant, who was captured from the wild decades ago and held in inhumane conditions in captivity. The non-human rights project case, the issue that's being considered there is whether the common law right to bodily liberty, protected by a common law habeas corpus, can be extended to animals like Happy. And that'll be a really interesting case, in large part because it's the first time that the highest court of a state or in any jurisdiction in the United States has agreed to hear an animal as a named plaintiff and to consider whether animals have standing to be plaintiffs. So I would definitely keep an eye on that, and the briefing and other proceedings for that appeal are wrapping up over the next couple of months here, and then there should be a decision, I would guess, sometime in 2022 in that case. So those are some of the issues related to animals as plaintiffs and animals as clients. Thanks a lot for listening, and I'll stop there and open it up for questions. Thanks.
The first question I'll ask was posed to Will, but I think any of the presenters could answer it. With regard to humane washing, the person asked, what about the media's role in not adequately countering the problem? Do you think they have some sort of incentive to benefit animal agriculture, and perhaps that's why you don't see as much media attention as you might otherwise regarding the problems?
Yeah, I can chime in, and Caitlin and Chris, happy to hear your thoughts as well. I read this question for the last hour and was kind of trying to figure out what the golden answer is. And I don't think there is one. I think it's a tough nut to crack, to be honest. And we can get the best video, we can get all sorts of cruelty, but to some extent, you know, if we can't get it out to the public because a media organization has an agenda or, you know, has a bias towards certain things, then that's a tough issue to crack. I mean, we have people who are employed and this is their job, is to try to get through some of those filters and get things out to the mainstream. I mean, at the end of the day, everything that we are doing with animal rights is about sort of shifting this paradigm that animals should not be treated as commodities and that it's not proper to be consuming animals. And to some extent, that's where the media is anchored. So it's a bit of a tough issue to crack. I know people have had success, you know, building individual relationships with reporters and just sort of getting a friendly ear for people to listen to things. There are a lot of alternative news sources out there, you know, organizations that are vegan friendly or animal rights friendly. And I think using those helps. I think our video, you know, to the extent that we can get our undercover video out on the mainstream, it is to some extent irrefutable. I mean, the video shows what the video shows, so it can't really be spun. But I don't have a magic answer. I think it's a long, slow fight about sort of shifting this paradigm. I think things like using alternative resources, you know, building relationships with reporters, finding stories that might sort of tie in with the current media hook. I think those things help, but I wish I had a better answer.
The second question I think came up during your presentation, Caitlin, and I'm going to paraphrase a little bit here because there was sort of a lot to it, but the gist was sort of, it was really getting to standing and why can't people sue, because they are seeing all the violence that's happening to animals, you know, in the factory farming context or other contexts. Is that something that could be a basis for standing?
Yeah, I mean, there are circumstances in which like perceiving something that is like personally harmful to you or is psychologically damaging could be a basis for standing. That is something that we do occasionally assert in our Endangered Species Act cases, like the ones that I described, for example. That would be, you know, it's called aesthetic injury standing, and the argument is basically that that the plaintiff has some sort of unique connection to the animals such that it is very upsetting, very traumatizing, very damaging to them to perceive the animals being mistreated in the way that they are by the defendants in the case, and that the defendant's conduct needs to be stopped, needs to be enjoined in order to remedy that injury. That form of standing is something that is pretty broadly recognized in jurisdictions around the country, certainly in federal jurisdictions. It's recognized everywhere. So that's something that we use fairly routinely. We also use, you know, standing on the organization's own behalf under a decision called Havens Realty, which has to do with diversion of resources for us, and then also associational standing, which kind of ties into aesthetic injury standing, in that the argument is basically that you, as an organization, have a membership who is uniquely injured by seeing this horrible stuff happening, and so you can assert claims on their behalf. Does that answer the question?
Yeah, I thought that was perfect. Will or Christopher, do you have anything to add? Okay. The next questions, we had a pair of questions that came up during Christopher's presentation. One is a fun question. Have plaintiffs in any of these standing cases, the personhood cases, I think is what they're focused on, been hit with frivolous claims damages when they've lost? And then a related question, have there been any cases granting or recognizing non-human animals legal personhood?
Yeah, so with the first question, with animals as plaintiffs, the answer is no. I'm not aware of any sanctions being assessed against them, and that wouldn't really be appropriate. It's pretty clear that animals that they do enjoy legal rights, like the right not to be abused. It's the benefit to the animals themselves, not just to like the animal owners. So in these cases, I think it's right that animals that they are persons and they have standing, and we're trying to get the law to catch up with itself, really, by bringing in these types of cases. And there was you know, and of course, even if you disagree with that conclusion, the bar is, you know, frivolity or bad faith. And so you'd really need to bring essentially exactly the same case without any kind of good faith distinction, I think, before you would run a risk of being sanctioned for bringing one of these cases. And, you know, in the Non-Human Rights Project case, this is the Lavery decision where the New York Court of Appeals declined to take up that case a few years ago. This was an earlier NHRP decision case, and there was a concurring opinion essentially saying that they raised a pretty good point, and I don't know why we're just arbitrarily discriminating against animals here. So yeah, there's at the very least there's room for disagreement. And sorry that I'm droning on a bit with that second one. Have there been any cases granting or recognizing non-human animal personhood? There have been some decisions in other countries recognizing animals as persons, that they have standing, that they have habeas rights, that they can go to court. And in fact, just yesterday we actually leveraged that one of those precedents in Colombia. There's a lawsuit there on behalf of some Pablo Escobar's hippos, who the government, well, they're now invasive because they escaped from his property, and the government has a plan to kill them. There's a lawsuit to protect them, and we leveraged a U.S. statute 28 U.S.C. section 1782, which allows interested persons to obtain discovery in the United States in connection with the legal proceeding in another country, and a judge signed off on the hippo's right to obtain testimony in the United States based on that Colombian precedent. So definitely a lot of movement happening on this front internationally and in the United States.
Very cool. And then the next question, I think it's for all of you really, and it's an important question. We had several related questions basically about, how can folks get involved in animal rights or animal welfare litigation, coming from Big Law Associates, who are obviously already attorneys, as well as law students. And I think, given the three of you really are superstars in this field, I just think it'd be really valuable if you each take a little bit of time to, provide some thoughts on that.
Sure, I'm happy to go first. I always enjoy this question because I went through my own struggle to get into the field, and I'm happy to be here and love to talk to people about it. But I think there's a host of different ways depending on where somebody is. I mean, for law students, I always encourage people to go to conferences like this to network and engage. Law students usually have writing assignments, and if they can pick an animal law topic and write on that and develop some expertise and make some connections through that. We have people reaching out to us, attorneys and law students who just want to volunteer or who want to intern, and we often have projects for them. There are state bar committees that have animal law groups and those types of things. Honestly, I think the best thing I could say is just to take the initiative. There's lots of different paths in, whether that's networking with a local group or reaching out to a national group or figuring out a project that they can do on their own or pro bono work. I think the first step is just looking for opportunities and making connections with people in the field. And I think people would be surprised. A lot of people are willing and able and happy to talk to people to give them some exposure.
Yeah, to kind of follow on what Will said, I think networking is critically important. It has been for me. The first time I went to this conference, I think it was actually like 2002 or 3. I was a junior or senior in college at the time, and I knew I wanted to get into this field, and so started to kind of build relationships from there. And then when I was in law school, I went to UCLA because it had just gotten this grant from Bob Barker for the study of animal law, and I wanted to go to a school that had some resources already dedicated to this. And so through that program, I met a guy named David Wilson, who was a partner at the firm where I started out. And he was the one who talked me into starting out in Big Law. And I spent 5 years there because he persuaded me to do that, to get some training first. And then when I was there, he made sure that I could do pro bono work for animal groups. So I actually did a pro bono rotation for what was then Compassion Over Killing and is now Animal Outlook, Will's organization, when I first started practicing, and then, maintain those connections. And then ultimately 8 years down the line, after Sally Mae had been satisfied, I was able to finally make the transition to full-time animal law, again, through some of the relationships that I had established through those connections.
Yeah, I think what everyone's saying is spot on. My 3 steps of advice would be immersion, networking, and initiative, to borrow some of the words that people have already said. And I think immersion is actually really important. What I mean by that is reading books, reading decisions, just having the curiosity and keeping your finger on the pulse of things. Following organizations on social media, or even just going to their website to kind of read what cases are they doing and what are they up to. There's animal rights, current debates and new directions. Would be I think an interesting book to read. But just take just immerse yourself in what's going on in the issues and have some critical thoughts about it. Second, with networking, that's can be anything from a conversation at an event like this to volunteering or doing an internship. And it's really important, I think, to make a good impression. So if you're going to do work, volunteer, don't commit to anything that you can't do a good job of, and then do a really good job, because it's a pretty small community. So if you have one person vouching for you who really likes you, that can go really far away. And then lastly, initiative. I think even if there's not an opportunity right away for you to apply for a staff attorney position, for example, there's so many animal issues that need to be addressed. And just to give an example, I have a friend who's a professor, an environmental professor at a community college, and one of her students is part of this group that help salamanders and amphibians cross roads during the breeding season, when they're trying to go down the hill and get into a lake to lay eggs. And I thought, just for that one local issue with that one species of animal, you could be going to this is in California. You could go to Caltrans, our local state agency for highways, and go to every meeting and be like, hey, you're not considering this, the salamander breeding patterns in this road construction plan. Potentially even file environmental review lawsuits and things like that. And so there's a lot of work you could do just for such a narrow micro issue, and then just multiply that for any local area by 100 or 1,000 for all the different issues that could be there. And I promise you, even if you can't find someone to employ you full time, you can definitely find animal law projects that'll be impactful if you just keep your eye open and have some initiative.
Perfect. Those are great answers. And I fully agree with all of them. The next question I think is probably directed at Will, and it's basically about a coalition building, especially in the factory farming context. What can animal rights lawyers do to partner with other interest groups, workers groups or other social justice activists to try to, tackle a common problem?
Yeah, I think the good news is, at least from my experience, I feel like that's been happening a lot, and I can give a couple of examples. And so there are a number of lawsuits to the Department of Agriculture related to what's called the modernization of slaughter for chicken and pigs. And the pig line speeds, or the pig slaughter lawsuits, have brought together a very wide and sort of diverse coalition of people. There are worker safety issues, there are food safety issues, there are animal welfare issues, there are environmental issues, and just sort of the volume of discussions and information sharing and coordination between those groups is nice to see, because a lot of the issues are the same. I mean, the Department of Agriculture may be doing X, Y, or Z, but the impacts are varied and it impacts different groups. And so I think it's good to know that. Sometimes we have blinders on and can't see that there are issues that might intersect, and there's more power in coalitions. But I personally feel like there is an acknowledgement that there's more value in doing that, and at least in a number of spaces in the administrative law space, I feel like that's happening. So I think it behooves us to recognize that in all of our cases going forward, and just to sort of check, hey, is there another group that might be impacted? Is there a coalition member that I might not have thought of that I can loop in? So I think that's sort of a measure that we can all take.
That's perfect. Christopher or Kaylin, did you have anything to add or any comments you wanted to make? Okay, I apologize to everyone. We had a ton of questions, but I don't think we have time to try to sneak another one in. So I'm just going to wrap it up now. But we really do appreciate all the questions, and join me virtually applause to all the presenters who did such a fabulous job and are just great attorneys doing great work for the animals. I hope you enjoy the rest of the conference. Thank you very much.